Good morning, everybody. Welcome and thank you very much for joining us for our HR Law webinar today, in which we're going to be covering a roundup from 2025 and then looking ahead into Q1 2026 and beyond. So just by way of introduction, my name is Daisy Jones. I'm a partner in the employment team at Fox Williams, and I'll be starting us off with a recap of the new employer obligations that we've had come into force in this past year. I'll then begin our perennially topical session on the Employment Rights Bill before passing the baton on to my fellow employment partner, David Williams, who'll look at some of the collective aspects of the bill. Arjun Majumdar, a legal director in our commercial and technology practice, will then talk about data protection developments for employers. And last but not least, we'll hear from one of our legal directors in the immigration practice, Adele Standard, for an update in that area. So a few admin points. The webinar is going to be recorded and it will be made available to those who have registered but are unable to join us this morning. We will also be circulating the slides after the event. We're very happy to take questions on the topics under discussion today, but if I could ask that you put those in the question and answer box, so the Q&A box on your screen, rather than the chat box, and we'll aim to cover those in the Q&A session if we have time once we've finished the material. So as I say, I'm going to start with a recap of some of the key employer obligations that have come into force this past year. And what I'll be looking at in kind of a quite short order, so we'll go through it quite a lick, is neonatal care and pay, gender definitions following the For Women Scotland case, a new failure to prevent fraud offence, which is not necessarily strictly within the HR space, but I think will kind of potentially touch on what you may all be looking at in your companies. And we'll then look at the ongoing proactive duty to prevent sexual harassment. So just to start off with neonatal care leave. So this has been available from April 2025. It's a day one right for all employees, and it's a right that hinges off of neonatal care from a child. Employees are entitled to up to 12 weeks of leave per every week that the child spends in neonatal care. But importantly, you've got to remember that neonatal care has got to start within 28 days of birth. And it has to last for effectively an 8-day period. So what that does mean is if a child moves out of that 28 days of birth and later encounters difficulties, the parent won't be eligible under the statutory regime for neonatal care leave or pay indeed. This is a leave that can be taken alongside other family leave. So I think what we'd anticipate most individuals doing is tagging it onto existing maternity, paternity or shared parental leave. And it's leave that's got to be taken within 68 weeks of birth. There are, as you'd expect, kind of certain notice requirements in the regulations. But one thing to remember, as with some other types of parental leave, it has to be taken in weekly blocks. So you can't kind of split the days out unduly. For individuals who take the leave, their full employment protections apply. So again, similar to other family-friendly leaves that we have. So broadly speaking, we're looking at the right to return to the same or a suitable alternative job. They're protected from detriment or dismissal because of the fact that they're taking the leave. And if they're within a protected period associated with the neonatal care leave, they get priority for suitable alternative roles in a redundancy situation. So aligned to that is the provision of statutory neonatal care pay, and the pay is available for up to 12 weeks of neonatal care leave. And again, it has to be payable within 68 weeks of birth. It's paid at the same statutory rate as paternity and shared parental pay. But unlike the leave, which has no service requirement, to be eligible for statutory pay, an employee has to have been employed for 26 weeks by the relevant week, and they also need a certain level of earnings. And again, there are various notice and evidential requirements in order for employees to receive this pay. So moving on to where we are after the For Women Scotland case, you might recall that this was the Supreme Court decision which looked at the meaning of women, men and sex in the Equality Act. And the findings of the Supreme Court when they looked at the parliamentary intention and the drafting of the Act was that the references to women, men and sex in that Act are intended to refer to biological sex. And so what that means, broadly speaking, is when we're looking at the definition of woman in the Equalities Act, that's going to be to someone whose sex is female at birth, which would not include trans women with a gender recognition certificate. Obviously, there are sort of ramifications to that ruling, and we would typically look to the Equality and Human Rights Commission for guidance on how employers should be interpreting the ruling and ensuring they have a kind of fair and inclusive workforce. At the moment, the interim update that the HRC had provided has been removed pending finalisation of a draft code. And that code went up to the Minister for Women and Equalities for approval on the 4th of September. It's still waiting for approval from the Minister, and then it will be laid before Parliament, and then it will come back to the HRC. So for the time being, I think a lot of employers are in a bit of a wait and see pattern pending that draft code, but it's one to kind of watch this space on, and we'll hopefully get more clarity on the position in the next year. So then the next thing I wanted to just touch on with you all is a new offence that came into effect from the 1st of September 2025. And this is an offence of failure to prevent fraud. And I appreciate this isn't necessarily strictly within the classic HR space, but I can see that it might touch on some things that you might be required to work on and support your organisations with. And certainly it's something that is important that your employers have on their radars to the extent they don't already. So if you're a large organisation, and there are various threshold tests that we've got on the slide, you need to meet 2 of the 3 threshold tests. You can, as an organisation, be criminally liable if an associated person commits a certain type of fraud offence and the organisation itself lacked reasonable fraud prevention measures. And there's various sort of regulatory requirements and boxes that you have to tick to fall within the scope of the offence. A few things to flag. It's a strict liability offence. So what that means is that if, say, an employee commits one of the specific acts of fraud that are covered by the Act, and the organisation lack the reasonable fraud prevention procedures in place, there's no need to show that the senior management knew about the fraud. There's liability that will apply automatically, and that will also apply even if there's no gain from the fraud as well. So it's potentially quite a wide-reaching piece of legislation, and at the moment we're still waiting for a test case to come through, which will probably sort of create a bit of a shockwave, we expect, amongst employers. So as I touched on, an employer will have a defence to this claim for failure to prevent fraud if it can show that it had reasonable procedures in place to prevent fraudulent activity. And this is where I think it might touch on some of your own practices in the HR sphere. So some of it is sort of corporate focus, so that is a clear top-level commitment and an anti-fraud culture. There's an importance around having fraud risk assessments and proportionate controls in place, but we also need to be thinking about carrying out due diligence on staff and on contractors, and that might be something that touches on your roles as HR professionals. Importantly, we also would expect employers to have to train and communicate to staff around the importance of spotting fraud and knowing how to report concerns. So that speak up culture, which again, a lot of you will work on and have sort of control of in the people space. And you'll also need to make sure you can show that you've been monitoring and reviewing your processes, because ultimately, unless you're able to show that you have these fraud prevention measures in place, in the worst case scenario, there are unlimited fines available for employers that get this wrong. So the final kind of 2025 look back I want to touch on, and I know I'm slightly stretching this because this is legislation which came into place in October 2024, is the duty to prevent sexual harassment. And I'm sure you'll all have heard people talk around this duty before. The reason we wanted to include it is that we're starting to see in the practice some test cases coming through where claimants are bringing claims which include a failure from employers in respect of this duty to prevent. And actually, we're also finding certain employers are not able to adequately demonstrate that they've complied with the duty. So we just wanted to kind of flag this with you all. Remember, this is a proactive duty, so you have to, in advance, take these reasonable steps to prevent sexual harassment of employees in the course of their employment. And this extends also to harassment from fellow employees, but also from third parties. So that might be clients, customers, suppliers. It's a very wide-ranging duty. And it is also one that, as we approach the festive season, I think is kind of ripe for attention kind of in advance, because unfortunately, as we all know, we tend to see a spike in complaints of harassment at this time of year. So I just wanted to give you this as a sort of checklist of things you might want to think about in the coming kind of weeks as you get into party season. The first, which is really critical, is your risk assessment. Now, we hope all employers have a risk assessment in relation to preventing sexual harassment. If you don't, please put this in place. It's the first document you'd be asked for if you're having to defend a claim in this area. And to say it kind of provides the touchstone of how you're going to show your defence to the claim. If you don't have a risk assessment, there's some good guidance. There's some examples on the EHRC website, so you can look there if you need. Adjoining that is your policies. So I know we work with a lot of employer clients when the duty first came into force around updating their anti-sexual harassment and their equal ops policies. So just have a little bit of a look through, make sure that they're fit for purpose, but also think about whether you need any additional policies. So that might be things around kind of a better or improved code of conduct. Do you need specific guidance or frameworks for how you expect people to behave at work-related social events? So those might all be things you want to kind of document or build into policies. Think about your comms plan, again, particularly at this time of year, and make sure people understand properly the standards of behaviour expected of them. And linked into that is your training program. So hopefully you have sort of regular training and updated training to help your employees understand their obligations and what they should and shouldn't be doing. Make sure people understand what your speak up processes are. And I suppose importantly, make sure you have speak up processes in place so that if someone is concerned or has something they want to raise or complain about, they know where to go, they know who to talk to. And that is all kind of clear to them. Keep things under an ongoing review. So this is not a static duty. You do need to revisit it and refresh your risk assessment. If you have an issue that crops up, revisit and think, why did we get this issue of sexual harassment? Is there something we could do better? And kind of aligned to that is make sure that where you get complaints, you're recording them and you're reporting them. So do you have an escalation report up to your exco, up to your kind of board, so that they've got visibility over what's happened? Because obviously there's a big cultural piece here around ensuring what we know people would call now psychological safety at work, or just a safe place to come to work. And as I say, it's all really particularly critical as we move into party season. So that's the end of 2025. We're hurtling towards 2026 at a kind of rapid pace. And so we're going to kind of start off with looking a little bit at the Employment Rights Bill. So we've got on this slide a bit of an overview of where we are. There's a lot of detail here. As I say, we will send you the slide so you can see this, but it's quite a helpful kind of where we are now guide. I would say, remember that a lot of the provisions in the bill are subject to regulation and consultation, so it remains quite a kind of fluid piece. But we do have some things that are going to be coming into force in April 2026. So I'm just going to touch on a few kind of small administrative points before handing over to David. So things just to make sure you've got organised for April of next year: changes to statutory paternity and parental leave. As you'll know, historically, employees have had to have a service requirement to be eligible for this. That is going to be removed from April 2026, so it will become day one rights to both of those leaves. And the other thing that is going to change is the approach to statutory sick pay. At the moment, that's payable from day 4 of sickness, and it's going to become payable from day 1. And we're also going to see the removal of the minimum earnings requirement for that to be paid. So those are just admin things just to make sure you get sorted, update your policies to reflect those. But with that, I'm going to hand over to David, who's going to talk to us a bit about the kind of collective elements of the bill.
Thank you, Daisy. Let's move on to the next slide. So I'm going to start off today by talking about the new Fair Work Agency. So this is a new statutory body that is going to bring together pre-existing and new statutory powers. So what are those things that are going to be covered? Well, firstly, it's the work of the Gang Masters and Labour Abuse Authority. Luckily, I've never come across that in my career. But it will also cover national minimum wage, statutory sick pay rules, domestic agency rules. Interestingly, sums ordered by the Employment Tribunal or agreed in a COT 3 via ACAS, which I think is in some ways, welcome development. And finally, statutory holiday leave. Apparently, and I don't know whether this is true, but it is said that there is £2.1 billion of holiday pay that is owed to staff. In terms of powers, this new body is going to have wide-ranging statutory powers, including inspection, so it'll be able to go to your premises and look at your documents and access your systems. It'll be able to issue civil penalties where they're relevant under the applicable legislation. In certain circumstances, it will be able to bring legal proceedings against employers, for example, where there is a case in the public interest. And as part of that, it will be able to provide advice, including legal advice, as well as issuing orders and recovering costs. So wide-ranging powers of this new statutory body, which will come into effect apparently in April 2026. And it's also worth noting that the coverage of this body may well be extended. So on to the next slide, we're going to talk about collective consultations in relation to redundancies. So the main change here relates to the maximum protective award, which applies where an employer doesn't consult collectively in relation to a redundancy exercise. And that's increasing from 90 days pay to 180 days pay. And I should say that's a real day's pay, not a capped day's pay, per affected employee. And indeed, that cap may be increased by up to 25%, where the employer is found to have unreasonably failed to consult. So the maximum penalty is 225 days pay per affected employee. I think that will stop many employers either not following the obligations or alternatively simply trying to buy staff off to not bother. They're also making changes to the trigger for collective consultation. Now, collective consultation will still be triggered where 20 or more redundancies are proposed. However, it's going to make a change to the requirement that those redundancies had to be at a single establishment. In future, the 20 or more redundancies will apply to aggregate redundancies across the employer's businesses in the UK. And that's, of course, to deal with the issues relating to the Woolworths case, where each branch could be found to be a separate employer, depending on the facts. And what's staying the same is the duration of the collective consultation, although the government has said that it will, in time, look at that. And these changes are intended to come in 2027. So let's move on to the next slide. So I'm going to tell you about some wide-ranging changes to union rights and laws. It's really important that you pay attention. Now, I've summarised these changes on the slide. There's going to be a new right to inform workers that they have the right to join a union. There are going to be union access agreements, so unions can apply to come into your business and speak to your staff about union-related issues and recognition. And they are lowering the bar for union recognition and industrial action, as well as promoting or increasing individual rights and protections for people involved in trade union activities. So these are wide-ranging changes that are going to affect most businesses in the UK in some way, and they are going to create some red tape and other potential issues. So it's really important you pay attention. These changes are going to come across at various timings. They're not all in a logical order, which is because some of these rights are pre-existing and some of them are new. So the first right is a right to tell workers that they have the right to join a trade union. And their employers will need to issue a statement setting out the information I've set out on the slide, a brief neutral overview of the functions, the statutory rights of trade union membership, a list of trade unions, and a signpost to the government's website. Now, this will either take the form of a standard template where the employer will fill in the blanks, which is the government's current preferred option, or the employer will be left alone to try and draft something. And that statement needs to be delivered directly to new employees by letter or by email, we suspect, depending on where the regulations get to. But for existing employees, it could either be delivered directly or it may be indirectly by appearing on some sort of poster or board within the workplace. Again, I suspect there'll be stringent rules around that. If the statement is delivered directly, it's likely there's going to be an obligation that it will need to be updated annually. So you'll have to remind employees of this right once a year. So that's going to be a real trip hazard for many in businesses, particularly small businesses, because there is no small business exemption for this. If you fail to comply with this right, there's no standalone right to bring a claim. It's like Section 1 of the Employment Particulars. But if you bring another claim, such as in relation to sex discrimination, you can add this claim. And if you do, you can get compensation up to between 2 and 4 weeks capped pay. The government's consulting on this at the moment, so if you don't like it, get involved in that consultation with implementation as of October 2026. So the next right is possibly a real challenge for employers. So this is a new right where trade unions can make access requests to employers, and those requests will involve trying to meet, support, represent, recruit, and organise workers, regardless of whether they're trade union members, to facilitate collective bargaining, but not to organise industrial action, which is covered by separate rules. So those are wide-ranging rights. All they have to do is ask. And when you receive a request as a business, then you have 5 days, 5 working days to respond to the request, and then 15 days to negotiate with the union. So that's a perilously short period of time. And if you don't reach agreement, then the union can within 25 days go to the Central Arbitration Committee for a determination as to what the access agreement should say between the parties, i.e. what rights the trade union should have. It's anticipated the government will issue model access agreements to help facilitate this process. So if you're trying to push back on something in the model terms, then that is likely to be quite difficult. We don't quite know what the model terms will contain. For example, will the employer know what the communications say? Will you be using the employer's email system? Will there be other rights that apply? Again, all this will need to be worked out. But there is, luckily for small businesses, there is a small business exemption when there's 21 or fewer employees, and the employer can refuse an access request where it's reasonable and it recognises a trade union. So, of course, an employer could face multiple requests from multiple unions for access agreements, causing lots of red tape, lots of disruption in the business, potentially, or time-consuming involvement of staff. May actually find it better to recognise a union to try and stop this happening. Again, we'll have to see what happens in the regulations, but lots of room for unintended consequences here. If an employer fails to comply with this obligation, then a complaint can be made to the Central Arbitration Committee, which I suspect is going to be very busy over the next few months, and they can issue a penalty for single breaches up to £75,000 and for multiple breaches up to £150,000. So not an insignificant sum. Again, there's consultation on this until December and implementation as of October 2026. If you don't like it, get involved in that process. If you do like it, then of course you can support it. Moving on. So we have informed staff, we have access agreements, we've got unions coming in, talking to staff, using our facilities, and the end game, of course, for the union is to go for recognition so they can support workers' rights. Now, the government is going to make it easier for unions to be recognised. So at the moment, there is a 10% union membership requirement in the bargaining unit for statutory recognition, and that's going to be lowered to between 2 and 10%. We understand it's likely to be 5%. So 5% of people in the bargaining unit have to be members of the trade union in order for the recognition process to start. As to the ballot requirements, currently unions are required to receive the support of the majority of workers in the ballot, and 40% of staff in the bargaining unit have to turn up. And the bill is going to remove that 40% requirement. So if there's apathy, if 90% of your staff don't turn up and the only ones that do are the ones that really want recognition now, that is going to work in the union's favour. And that's been a barrier to union recognition in the past. The legislation is also going to stop tactics by employees to try and dilute support, such as expanding the bargaining units and various other means. So there's going to be anti-mischief provisions in the legislation. And overall, the process is going to be simplified. Now, the timing for this coming in is going to be April 2026. We talked about the right to inform, access agreements so they can talk to your staff, on the back of which they go for union recognition. Once they're recognised as a union, the next step, if they don't like something the employer is doing, is going for industrial action. And this is going to be made easier. So now the minimum 50% requirement for a ballot for industrial action is going to be removed. So all the union needs is support of 50% of staff who actually vote. So if there is apathy and people aren't interested, they're not members of the union, they don't know what this is about, then that's going to work in the union's favour. So again, this is going to make it much easier for unions in a practical way. The notice period also that the employers must give when they're going to implement this, and it is going to be industrial action, is going to be reduced from 14 days to 10 days. So the employer is going to have less time to make arrangements to deal with the business impact of the industrial action, which is likely to have higher impact. The validity of the mandate is going to last for 12 months rather than 6 months. So if there is a vote for industrial action, there is a potential that that can apply for 12 months. That's going to be much longer. That's going to increase the bargaining for the union, which may mean the employer is more likely to agree to whatever the union, whatever they want. There's going to be enhanced protection for workers who have rights not to be subjected to a detriment and such things, which I'll also come on to. So the implementation for this is early 2026 and October 2026, depending on the precise nature of the rules that come in. So moving on, we are having reforms that are going to protect individuals and those involved in the unions. So the first one is there is going to be an increased right to take time off for trade union activity. So if you have any trade union members, they're going to have the right to paid time off to do more things. Including there's going to be a new equality representatives who are going to be charged with supporting their members dealing with equal sex discrimination and equality related issues within your business. There's also going to be a right for individuals to use facilities. Again, we don't know the precise extent of that, but it may be a room, photocopying, access to email systems and that sort of thing. They're also strengthening union members' rights so that they are not discriminated or blacklisted when they're involved in trade union activities, or where they're dismissed for taking part of industrial action, or where there is a detriment short of dismissal for being involved in that industrial action. I should add that there are other changes afoot. There are going to be electronic balloting as part of the processes I've just described to make the process more streamlined. And the final thing is there is a presumption that any money that comes in the form of subscriptions to unions can go to political parties unless the employee opts out. And that's something that's part of the ping pong between the House of Lords and the House of Commons at the moment, because it's obviously a controversial term from a political perspective. So the timing of this, again, is various depending on the individual rights, which I don't have time to go into now. So on to my next slide, just to briefly, summarize what should you be doing preparing for these changes. Well, I think it's really important that you take a temperature check of your workforce, your industrial relations. If you have a staff body, you might want to give it teeth. You might want to encourage it because that may be a way to fend off trade union recognition if that's important to you. Or you may want to establish such a body. Candidly, you should have probably thought about that a year ago. You also need to start thinking about what happens when these rules come in. How am I going to prepare? Some of the timelines, for example, dealing with access requests are very short. What are we going to do if and when we get one? What happens if we get 5? What sort of arguments can we put forward? What's important to our business? What would be supported? What should we be saying? It's something you need to have a plan to prepare for. I should say that there's other practical steps like updating documents and policies and such like. And again, that can be done nearer the time. I think the final thing is this is likely to have quite an impact on your business. It's red tape, but it could also have a fundamental change to the industrial relations within your business within a short space of time. You are going to need people with different skills liaising with the union, and you need to be building, different relationships potentially with them. So you need to be thinking about that. And as part of that, I think it's really important that you warn your business that this is happening and that you start preparing for it. Okay, that's probably enough for me, and I'm going to hand over. Thank you.
Thanks very much, David, and good morning to everyone. I'm going to be doing a very high-level overview of recent developments in UK data protection laws from an HR employer perspective and what sort of things to prepare for as the year soon comes to a close and we head into 2026. So I'm sure we're all now quite familiar with the GDPR. It's been in force since 2018, and we've learned to live with it. Just to remind ourselves, the GDPR is an EU law, but after Brexit, the UK retained a UK version of the GDPR on its statute books. And because of Brexit, the UK can, of course, diverge from the EU GDPR if it wants to. And up to now, the UK GDPR has more or less remained the same as the EU version. That's all changed now because the big data protection news story of this year is the introduction of the Data Use and Access Act 2025, which makes, and I would emphasize this, nuanced changes to the GDPR. And I'm going to briefly cover what some of those changes are in the HR context. But the really key takeaway is that the new act does not replace the UK GDPR or Data Protection Act 2018, nor does it do any sort of massive overhaul. So if there's one thing to take away from my talk, it's that the UK data protection framework overall isn't really going to change or hasn't changed, and it's very much here to stay. Also, most of the changes are not yet effective. According to the UK government, they will be phased in over the course of next year, but we don't have any definitive timescales as of yet. So it's a case of watch this space. And just as a reminder, I'm going to be talking about the changes to the UK data protection laws, but I'll briefly talk about developments in the EU towards the end. Next slide, please. So what does the Act do, and how is this relevant to you as an employer? The GDPR has this concept of automated decision making, and this essentially means processing personal data using automated means. In other words, there's no human intervention, no human involvement to make decisions that have legal effects or effects which are similarly significant. And such decisions would include the decision to consider or reject someone for a job. In other words, decisions made at any stage during the recruitment process. And so that's why it's relevant to the HR context, particularly in recent years where employers are looking at ways to perhaps leverage generative AI tools like ChatGPT, etc., to make decisions for them. The existing framework, so the current law, is very restrictive on automated decision making in the recruitment space. So unless there's meaningful human intervention, unless there's a human being involved, it can be a challenge to rely solely on AI at the recruitment stage without probably being in breach of GDPR. Now, that restriction is set to be relaxed by the new act. The upshot of this is that going forward, there will be a more permissive framework within which employers can, to a greater degree, rely on AI, particularly at the early stages of recruitment. But that relaxation is only really to a degree. First of all, automated decision making in special category data is still pretty much restrictive and will continue along the same lines as the existing law. And there will still be a requirement to embed certain safeguards, such as properly informing candidates as to as to the use of the technology being used to make decisions, allowing candidates to request human review, and also to challenge decisions made by the technology. That all has to be built into the decision-making process. And of course, there is still a need to carry out a data privacy impact assessment. So that requirement and all the other requirements of GDPR haven't really changed. And just as a reminder, the changes are not yet effective. We expect them to come in at some point in 2026, but we don't know when yet. There needs to be secondary legislation to make these changes effective. And we also need regulatory guidance to really flesh out the finer details, but we're keeping an eye on developments there. Complaints. So what the Data Use and Access Act also introduces is a requirement on the data controller to allow individuals, employees, to complain if they think there has been a breach of GDPR by the controller. In practice, this means if you haven't done so already, it might be the case that you already have a complaints process, but having some kind of formal complaints process, particularly having an online complaints form, which allows individuals to make complaints and then to deal with those complaints. The data use and access, it doesn't say too much. It says that you need to acknowledge the complaint within 30 days of receipt and then respond appropriately without undue delay. And I'm going to talk about DSARs very shortly, and often individuals complain on the back of a DSAR. And what this new requirement really does is it takes the burden away from the ICO, and it places an expectation on the individual to first escalate matters with the employer before going straight to the ICO, which is actually something that individuals should be doing anyway, something that the ICO encourages anyway. And again, this change is not yet effective, and we expect further finalized regulatory guidance to provide more of the detail. But again, we think it's going to be 2026 when that change comes in. So DSARs, obviously, this is a very hot topic. We know that DSARs can be burdensome on the employer. Those who have had to deal with a DSAR will know how time-consuming they can potentially be. We also know that DSARs are often weaponized, particularly in employer-employee disputes. Often the motive is not about exercising the right to privacy necessarily, but an attempt to dig up information as part of or in preparation for litigation. But as I'm sure you know, employees don't have to explain their motive, and DSARs have to be complied with regardless of motive. It is the employee's statutory right to request their data. And I thought I'd work backwards here and sort of give you the spoiler alert up front. The Data Use and Access Act doesn't overly relax or extend the rules on DSARs. Instead, what it does is it codifies or confirms existing aspects of ICO guidance. So you're probably not going to have to do too much extra if you're already following ICO guidance, which has always been reflective of best practice anyway. Irrespective of that, what are the key changes? So clarification of scope. So one is that the employer is within its right to go back to the employee making the request and clarify the scope of the request, especially if the employer, which is often the case, is processing a large amount of data about the employee. The law is not yet effective, but it's actually something that's reflected in ICO guidance already, so it effectively is effective. So let's say the employee makes a request saying, I want all the personal data you hold about me. Often they do that. The request can be quite broad without maybe giving much direction as to what exactly they're interested in. The employer can write back to the employee asking them to clarify the scope. The key thing here is that the deadline, which is 1 month to respond, or a deadline can be responded by a further 2 months if the request is sufficiently complex. But that clock is paused whilst waiting for the clarification from the employee. It's important to note here that you can't compel the employee to narrow the scope of their request, but you can ask to clarify. And of course, the employee is within their right to respond and say, as per my previous email, I still want all the data that you hold about me. And in which case you will need to carry out the appropriate searches. And this leads on to the next point, which is something else that the Act clarifies. And this is also effective immediately, is that the controller, the employer, when searching for the data, is required to carry out a reasonable and proportionate search. This isn't defined in the statute, but case law and ICO guidance do make clear that a high expectation is placed on the employer to find and provide the relevant information requested and essentially assist the data subject, the employee, in dealing with their request. The controller is expected to know of their GDPR obligations and to have designed appropriate systems to enable most searches. So what the reasonable and proportionate search condition is really getting at is that the controller is not expected to perform technological miracles, for example, to reverse engineer data that's already been anonymized or deleted. But if on a reasonable search that data is retrievable, then it should be included within the search. Also, recent case law has confirmed that when a DSAR is made to the company, don't assume, unless the individual clarifies in the scope of their request, don't assume that the DSAR is just being made to one department or one system. There is an expectation, obviously this depends on the scope of the DSAR, but there is an expectation on the data controller to carry out searches across the company. So just to summarize, the rules, as you can see, aren't fundamentally changing. And if you're following ICO guidance already, and there's a lot of information provided by the ICO on how to deal with DSARs, this probably isn't going to impact you a great deal. But this is a useful reminder to ensure that you have robust policies, procedures, and systems in place to deal with DSARs. Half the battle with DSARs is having those procedures in place so that if a DSAR comes in, hopefully the response is not panic stations, but it's following a well-rehearsed procedure. So, of course, there are, unfortunately, there isn't a one-size-fits-all approach with DSARs, and they do need to be handled on a case-by-case basis. But for example, if you've carried out data mapping, you have appropriate search tools, you work closely with, say, IT and other system holders, you know what systems and repositories to search, and overall, there's general good organization in terms of where the data sits and where to look for that data. You're hopefully going to save yourself a lot of the hassle that comes with a DSAR. Being prepared is very much half the battle. The focus on my talk has been on UK reform, and I'm going to finish up talking briefly about developments in the EU. First of all, international transfers. So after Brexit, the UK and EU essentially agreed to have mutual data flows. What this means is that personal data can flow freely between the European Economic Area, EEA, and the UK, and vice versa, without the need for additional safeguards, which essentially translates to contractual clauses between transferor and recipient. And this is based on what are called adequacy decisions, which were put in place post-Brexit. Now, the EU's adequacy decision for the UK is set to expire at the end of the year. However, the noises coming from the EU are that adequacy decision is very likely going to be renewed. A big factor, no doubt, being that the Data Use and Access Act, which I've been talking about, doesn't really cause a significant divergence from the EU data protection regime. So we're keeping an eye on developments, but as I say, the prediction is that it will be business as usual as far as transferring data from the EU to the UK is concerned, and nothing also changes in respect of sharing data, transferring data from the UK to the EU. That looks set to continue without the need for additional safeguards. And lastly, it perhaps be remiss of me not to mention recent developments in the EU, and I'll touch upon this briefly because you may have heard in the news recently that the EU are planning to make reforms, not just to the EU GDPR, but also other EU laws, such as the EU AI Act, which is very big news. In a nutshell, in light of recent developments in progress in AI and a desire to kind of leverage its uses and to help innovation and to stay competitive, and probably also due to mounting geopolitical pressure, what the European Commission wants to do is simplify, or what they plan to do is simplify certain aspects of its suite of data and AI laws, including GDPR. What I'll say for now is that we are very much at the preliminary stages, and they're just plans at the moment, and a lot of negotiations need to take place within the EU until the planned reforms are finalized. But for those of you operating in the EU, 2026 could shape up to be a significant year as far as new data and AI reforms are concerned. But as I say, it's early stages at the moment, and we are keeping an eye on developments as to what to expect from the EU next year. So on that final note, I will hand over to Adele.
So today I will be discussing the government's immigration white paper published in May earlier this year. Before I dive into the specific proposals, it's helpful to briefly explain the document. The immigration white paper is essentially a policy blueprint setting out the direction of travel for the UK's future immigration system. It isn't legislation yet, but it signals the major reforms the Home Office intends to introduce, particularly around skilled work routes, settlement, and sponsorship. For employers, it's important because it gives early visibility of the changes that are likely to reshape recruitment, compliance obligations, and workforce planning in the coming year. So, to briefly set the context for why the government is making these changes, the white paper sets out a clear political objective to create what it calls a controlled, managed, and skills-focused immigration system. like several governments before it, this government has been explicit that it wants to reduce overall net migration while ensuring that the routes which do remain open are tightly aligned with economic priorities and higher skilled roles. For employers and sponsors, this marks a continued shift away from the more flexible, broad-based sponsorship system we've become accustomed to since the introduction of the skilled worker route following the end of freedom of movement for EU nationals in 2020. The direction of travel is towards higher qualification thresholds, more selective role eligibility, and a system that's more firmly linked to productivity and high-value growth sectors. We're also seeing much firmer emphasis on compliance. The Home Office is signalling that sponsorship should be a privilege and not a default option, and that employers will need to demonstrate stronger internal controls, better record keeping, and clearer justification for each sponsored role. All of this means the operating environment for employers is likely to become more restrictive, more administratively demanding, and more scrutinised. And although the proposals are not yet final legislation, or not all of them are, the strategic direction is clear. So as we move into 2026, employers should prepare for a system that rewards higher skilled recruitment and places greater responsibility on sponsors to evidence compliance and workforce planning. So to turn to the key proposals in the white paper that will directly affect employers and particularly sponsors, we'll first discuss those changes that have already been implemented. A significant change is a return to the pre-2020 skills threshold of RQF level 6 for the skilled worker category, which is essentially graduate level roles. The government increased the skill level for sponsorship to RQF level 6 on the 22nd of July this year. And this means that many roles that previously met the RQF level 3 threshold are no longer eligible unless they appear on the temporary shortage list. For some employers, this has dramatically narrowed the pool of eligible sponsored positions. Alongside this, salary thresholds were also increased in July this year. The white paper indicates a move towards higher baseline salary levels to reflect genuine skill and reduce reliance on lower paid overseas labour. The general salary threshold for the new applicants is now, as of July, 41,700 per year, and that's up from 38,700. We've also seen the removal of some lower skilled role eligibility entirely. Social care is the most high-profile example flagged in the white paper, but other lower paid and lower skilled roles may also be removed or heavily restricted. And this will increase pressure on domestic recruitment pipelines for those sectors. In a positive move, however, on the 4th of November, the UK's high potential individual visa was updated to widen eligibility by expanding the list of qualifying universities to the top 100 globally, up from the top 50. However, a new annual cap of 8,000 applications has also been introduced for that route. So now to turn to changes on the horizon. A major proposal concerns settlement. The government has proposed extending the qualifying period for indefinite leave to remain to 10 years for many work routes. That has significant implications for retention strategies and for the expectations of current sponsored workers. Further information on this proposal was in fact released last Thursday, and the prognosis is actually looking much more positive than was perhaps feared when the proposal to extend the qualifying period to 10 years was first announced. The government has now stated that while 10 years will be a base qualifying period for ILR, that can be significantly reduced by meeting certain criteria. For example, applicants for ILR who have had a taxable annual income of at least £50,270 a year in the 3 years preceding their application can reduce their qualifying period by 5 years to 5 years. So essentially, there's no change for anyone above that salary bracket. Significantly, for those who have earned at least £125,140 in the 3 years preceding their application, they can in fact reduce their qualifying period by 7 years, meaning that they can qualify for ILR after just 3 years in the UK. Varying reductions also apply to those who have demonstrated integration by being able to demonstrate English competency to C1 level on the Common European Framework of Reference, those employed in specified public service occupations, and those who have worked in their communities. There are also reductions for family members of British citizens, global talent, and innovative founder migrants. Those in low-skilled roles, however, may face a qualifying period of as much as 15 years, And there are certain characteristics which also attract time penalties for qualification, such as breaches of immigration rules or claiming public funds. Additionally, dependents may not necessarily benefit at the same time qualifying period as their main applicant family member. So for HR teams, this is a key moment to map your sponsored staff by salary band, identify who will be impacted, and consider whether salary adjustments, development opportunities, or retention initiatives are appropriate. The government has also said that it will increase the immigration skills charge significantly by 32% as part of its aim to ensure employers contribute more to domestic skills development when recruiting from overseas. From the 16th of December this year, this will be £480 per year for small sponsors and £1,320 per year for medium and large sponsors. For employers with high volumes of sponsored workers, this will materially increase the cost of sponsorship. Employers should therefore factor the higher ISC into your workforce budgets and move up applications to before the 16th of December where possible. Another proposal is the reduction of the length of the graduate visa route. From the 1st of January 2027, this is being reduced from 2 years to 18 months, which tightens the window in which recent graduates can gain UK experience and transition into the skilled worker sponsorship category. The length of permission for PhD students will remain at 3 years, however. The UK government has also said that it's raising English language requirements across visa routes. For example, main applicants under the skilled worker route will need to evidence English proficiency at CEFR level B2 instead of B1. Adult dependents will also need to meet English language requirements, which they currently generally don't have to do. And the aim is to broaden the number of routes with language requirements and ensure stronger integration through improved English proficiency. The white paper also sets out a strong message around compliance. Sponsors should expect more audits, more data checks, and stricter enforcement of reporting duties. Sponsorship is increasingly framed as a privilege, not an entitlement, and the Home Office intends to hold employers to higher operational and governance standards. So the overall picture is one of tighter eligibility, higher costs, and greater scrutiny. For employers, that means now is the moment to analyse which roles are likely to stay within scope of the new rules, where the pinch points might be, and how your recruitment and workforce planning strategies need to adapt. So what should employers be doing now? Given the scale and direction of the proposed changes, employers and sponsors should not wait for the final legislation to be published before taking action. There are several steps you can and should be taking now to protect your workforce planning for 2026 and beyond. Firstly, audit your current sponsored roles. Look at every role you sponsor or expect to sponsor in the next 12 to 18 months and assess whether it meets the new higher skills and salary thresholds. Where if roles fall below RQF level 6 or below the anticipated salary levels, start thinking about whether those positions can be regraded, redesigned, or supported through domestic recruitment instead. Review your salary structures and budgets. With higher salary thresholds for sponsorship and potential reduction in the ILR qualifying period for employees earning over 50,270, or employers need to model the financial impact now. Identify any employees earning under 50k a year who may face a significantly longer path to settlement, as this may affect retention and expectations. Budgeting for salary uplifts or revisiting compensation strategies may become necessary to maintain access to overseas talent. Prepare for the increases to the immigration skills charge, which will add further cost pressure. If you have a large sponsored workforce or rely heavily on sponsorship for certain departments, make sure this is reflected in your 2026 workforce and financial planning. Consider the impact of the shorter graduate visa route. If you recruit international graduates, you'll have less time to identify talent, assess performance, and transition individuals into skilled worker sponsorship. Early talent teams should accelerate timelines and ensure graduates can meet the new skill and salary requirements within that shorter 1 year period. Carry out a sponsorship compliance health check and consider undertaking a mock sponsor license audit. The Home Office is clearly signalling a tightening of compliance expectations. This is the moment to strengthen internal controls around right-to-work checks, reporting duties, monitoring absences, tracking visa expiry dates, and keeping job details up to date. A robust compliance framework now reduces the risk of license issues later. And finally, look at your domestic talent pipeline. With the system moving away from lower skilled overseas recruitment, now is the time to invest in apprenticeships, upskilling programs, internal mobility, and succession planning. And that brings us to the end of the immigration section of the webinar. I'll hand back to Daisy.
Thanks ever so much, Adele, Arjun and David. That was all really interesting. We've got a couple of minutes for questions. I've just seen one pop into the chat box, Adele, which I think will be for you. The question for everybody is, are people with indefinite leave to remain now able to keep this and follow the citizenship application route as before?
Once the new ILR kind of base qualifying period applies, then that will apply retrospectively. So if you even if you're already in the UK, that will apply to you. If you're able to make the application before the new changes come into play, then you can still benefit from the general 5-year qualifying period. But it depends on when those changes come in and whether you qualify, whether you hit that 5-year qualifying point before the changes come into play or not.
Oh, so Adele, you're popular this morning. Another immigration query. Do the immigration changes impact skilled visa applications, so not sponsorship?
Well, skilled visa applications are sponsored visa applications. So, I mean, the immigration changes impact both sponsored roles and non-sponsored roles. As the changes come in, but all routes are being affected. But yes, skilled visas are sponsored visas.
Okay, we've got a little flurry that we'll try and get through. So just another one on immigration quickly, Adele. When are we likely to know the changes to 5 to 10-year indefinite leave to remain rules and impact to families benefiting from qualifying periods?
So I think likely we'll see that in the first part of next year. Lots of the changes are still under consultation, so it's generally expected that in Q1 next year we'll have more information.
Thank you. And then I think a couple of questions, David, for you before we close. The trigger for collective redundancy consultation was mentioned as 20 or more. I think if you could just clarify, David, is that 20 staff over a year period? It is the question, but I think the answer to that is no.
No, it's where the proposal relates to 20 or more within a period of 90 days. So the fundamentals of the law is not changing in that respect.
And then final question before we close, on union representation, would that apply to all types of companies, so including those where trade unions don't currently exist?
Yes, this is fundamentally important. In some respects, if you have a union, it's going to be easier because for things like access requests, you may want to say no. If you don't, these laws are much more relevant. And bear in mind, the union can apply just out of the blue to your business and ask for these rights to be applied and apply for a subject access request. So you do need to be prepared.
Thank you very much. So thank you, David. Thanks, Adele. Thanks, Arjun. And thank you, Bailey. Thanks to everyone who has attended. As I say, we'll be circulating the slides. We'll have a recording as well. So that will be coming through to you soon. And wishing everybody a happy rest of the year, happy festive period, and we'll see you in 2026.